Sam Seder, Emma Vigeland on the Majority Report. Want to welcome to the program Melissa Jacoby, law professor at the University of North Carolina, Chapel Hill, author of Unjust Debts, How Our Bankruptcy System Makes America More Unequal. Professor, welcome to the program. Before we get into bankruptcy, which I think is far more intriguing for people than one would think, and I say that as a son of a bankruptcy attorney. I just am curious, as a law professor, when you see the Supreme Court's ruling today, I'm sure you haven't had too much time to look at it, but I suspect that you might have some thoughts. What are your first thoughts on that?
Well, it has me thinking about power. It has me thinking about who's above the law, and that's a scary thing. Today's a somber day in that regard.
How do you guys, let me just ask you, like, broadly speaking, has there been, over the course of your career as a professor, an increasingly sort of cynical, has it been hard to fight the cynicism? Like, there is the idea with the law and lawyers is that, the Supreme Court justices would never start with a ruling and then reverse engineer, and that the law is very much based upon, the sort of the foundations that have been set over the common law and, of course, over the course of the of this country's history. How are you hanging in there as a law professor when so much of the sort of the varnish seems to be coming off that?
Well, I come from a long line of skeptics. There have always been people who understand that courts don't merely call balls and strikes, even when they say they do, that a lot of different factors go into how they rule, that there are political elements, that there are other factors. Now, the ability to weather the cynicism over time is a different matter. I do think it becomes harder, but I try not to think about this regarding me. I think about it regarding the American people. Yes, sure, in the last week, we know a lot of law professors have had to start changing what they're going to teach in the fall and what they're going to tell their students, but that's secondary to what the real world effects are of all of these decisions.
Yeah, and let's talk about that in the context of your book in Bankruptcy, because you're right. A bankruptcy law is something that touches perhaps more Americans than just about any other type of law out there, either because as individuals they deal with bankruptcy, or they're dealing with the implications of a corporate bankruptcy, or for that matter, a municipal bankruptcy. But let's just start with, before we get to bankruptcy, let's start with debt, and just like, if you could compare and contrast the implications of debt for individuals, for separate people, what we all perceive as people, and debt for what you call fake people, which are basically not just corporations, but any entity that is organized, may not necessarily be a corporation per se, but it could be a church.
For real life human beings, for families, there often is a strong need to use debt as part of their social safety valve. This is a society that has a lot of risk put on the individual and the household, even for things that are out of their control. It has been increasingly that way, and credit is what fills the gaps. At the same time that individuals are incentivized to use credit and incentivized to take on debt for all sorts of things, the narrative around when they need to cancel some of that debt is very finger-wagging and very unapproving in this country, no matter the circumstances, it often seems. And there's an effort to turn neighbor against neighbor in terms of judgment of why one person can't handle all the debt they have when someone else tries to do so. When we flip to the corporate environment, especially big corporations, I think the story is very different. Certainly, corporations have lots of incentives to borrow and sometimes are given rates that are considered extremely cheap when the average American family could use some cheap credit too, but it's not always available on those terms. And when they do run into trouble, the story is different. It's looked upon as a more rational strategic decision of how to move forward, and people are more likely to look at the broader consequences and say it's better for everyone if we let this company reorganize in bankruptcy. And so talk about economic efficiency and those sorts of things. We don't hear as much of that story with individuals, but we really should, because we can make a lot of the same arguments there.
There's a moral stigma associated with personal bankruptcy. It's almost the complete opposite for corporations. Then it's sort of almost like an astuteness at certain times that's associated with that. I mean, that's by design, isn't it? I mean, in terms of like, that's by design. I mean, we talk about bankruptcy adding to the wealth inequality and a couple other sort of measures of inequality, I would argue as well. By making bankruptcy a stigma on a personal level, that's by design, right? I mean, that's because the people that are the creditors on a personal bankruptcy are much more powerful. There's a power dynamic there that's different if a corporation has creditors, because a big corporation is going to have creditors who are probably less powerful than the corporation.
Well, and you mentioned the word power, and I think that's really important, because bankruptcy looks like it's about debt and money, but really it's a lot about power, which I think makes it fit in the narrative of what we're talking about today in court decisions and the like. Democrats and Republicans often don't agree on much, but in 2005, they joined together to say that bankruptcy should be more complicated and more expensive for financially distressed families in this country. And they proceeded to do exactly that. And they did that at the behest of the consumer credit industry, although there were a lot of other interests that piled on that effort as well.
How much?
I should just add,
Yeah.
that was Biden's bankruptcy bill.
Oh, yeah.
Right.
Yes.
I mean, your former professor, I mean, that was sort of almost like her origin story in terms of entering politics. I mean, prior to then, she's writing for Talking Points Memo and talking about personal bankruptcy, and that bankruptcy bill. And I want to get to, how it basically excluded student debt. But that bankruptcy bill was a Joe Biden, I think, drafted legislation, if I'm not mistaken.
Well, you're absolutely right in the general sense. I'd say the consumer credit industry wrote a lot of the legislation themselves. But at the time, as a senator from Delaware, he was very active in mobilizing that agenda. And he also was not receptive to pushback from fellow Democratic senators who were starting to have concerns. Now, he has come a long way on all of these issues. I want to give him credit for that. People do change their mind, or at least change their policy.
Right.
But it's part of the record that he was very actively involved and made it difficult for Democrats to dissent from those positions.
Yeah, he was from what they call it, the credit card state, or he always represented those interests throughout his history in the Senate. How much of the punitive nature about debt comes from the outgrowth of debtors' prisons, or basically the fact that they were done away with, I guess, in the mid 20th century, it basically being a continuation of that without having to lock people up for it?
Well, the irony is that there's a real difference between locking people up and the approach we have now, although both end up somewhat in the same place. Here's what I mean. When people are locked up for not being able to pay their debts, which sometimes still happens in corners of our world for certain kinds of obligations, but in general it doesn't, people can't repay debts while they're incarcerated. There aren't the mechanisms for them to make money in enough quantity to actually repay creditors. The problem is that, so we move out of that and we go into a system that says, what could possibly be wrong with encouraging people to repay as much debt as possible over time? They're not imprisoned, so surely they can devote some of their future wages to this. But there's lots of research showing that it just doesn't work that way, especially with the costs and fees on some of the credit, where people might have paid the principal several times over, but will never, ever pay off the debt. That is then going to change the choices they make about starting businesses, the education their children receive, and everything else in ways that aren't good for anybody. So whether the theory of the two comes from the same place, I don't know, but the practice ends up not being as different as it looks. I often say that we're supposed to have bankruptcy in America, an effective debt cancellation regime, so that we don't have to have Squid Game. We don't want to live in a Squid Game world where people fight to the death because that's the only way that they could pay off their debts.
All right. So, I mean, we have this concept of bankruptcy, which in and of itself is good. I also like the concept of bankruptcy because it expresses that, like, look, things don't always work out the way we want them to, and we still want to come out. It's a bad situation, and you want things to come out as beneficial for as many people as possible associated, both the people in bankruptcy and the creditors and society at large and whatnot. And so you do this. I mean, I like that concept. I would like to apply to a lot of our public policy things. But as you write it here, when the rubber hits the road, what happens is that bankruptcy seems to work for some people in that fashion, at least aligned with that concept, but not for others. And again, it basically falls to, for the less powerful, it doesn't work in that way, broadly speaking. And for the more powerful, it does. So let's just talk about, you give two examples of sort of fictional real people, I guess, that are aggregates of the type of things that people run into. One is Sylvia, and the other is Linda. And describe these two, because one is in chapter 7 and the other is in chapter 13, which are the two personal bankruptcies. And they have very different implications. And they also turn out to have not only different implications in practice, but they are correlated, and I think you would argue with reason, to specifically how people are located in our society and down to even race.
Yes. So the stories in the book are intended generally to make sure that people see this is not an abstract exercise to write about this, that the public can and should read this book on Unjust Debts, and that these are real people that are affected, and to show examples of how people who get into financial trouble trying to do all the right things end up facing a system that makes things very difficult to get out the other end. Sylvia starts having to take less time at work because she's caring for a sick mother. And when I used to do and be involved with the Consumer Bankruptcy Project, which did studies of the real people in bankruptcy over time. And I can tell you, Sylvia looks like a lot of the people that have gone through the bankruptcy system. And then one thing after the other happens. She loses her job. That means she loses her health insurance. When she ultimately gets another job, it may not pay as well. The benefits may be lesser. In the meantime, she did try to use credit cards because she was sure that things were going to change the next day. And that's partially what they're for, to fill the gaps when you can't pay 100% at one time. And so we go through Sylvia's story to start with a portrait that I hope most Americans can understand, that it does sound like someone they know or themselves could end up in that position. When we move to Linda, Linda is an African-American woman living in North Carolina who's trying to save her home from foreclosure. And this piece does come from my sitting in a courtroom of testifying under oath that she had applied for 1,000 jobs to no avail. This was in the midst of the financial crisis. She was doing everything she could and then taking odd jobs, trying to get help from family, renting out her house, anything to try to keep things going forward. She was against an uphill battle, however, because the only kind of bankruptcy that she could use to potentially save her home is this thing called Chapter 13, which is a repayment plan. You have to commit every last cent that you have, basically, to this plan. And it's still not going to help Linda because of the costs of her loan and the fact that she can't get another job. However, there are a lot of people in Chapter 13 who look like Linda. They're African-American families who have financial distress, who have been steered there even though they don't have a home to save. And ultimately, what Unjust Debts is trying to convey is a large body of research. I cite to the people who do all of this really important work that shows that African Americans are systematically getting less debt relief at basically a higher price in our American bankruptcy system.
Well, all right, and for folks at home, that's what we call systemic racism, where you don't necessarily have an institution that's doing it, but there is a system that is for any one of myriad reasons is providing worse outcomes because of people's race. So why would I be eligible for Chapter 7 versus 13? And then how in practice does that end up creating a racial disparity when we look at the numbers?
Well, when Congress rewrote the law in 2005, they might not have intended this, but one thing that they effectively did is make it impossible for me to explain that in a very short period of time. They made it so complicated. Basically, one of the messages from that law was that people who had too much income, if you were wealthier in terms of income, you should go to Chapter 13. And if you were less wealthy, maybe you can be in Chapter 7.
Wealthy as defined by income as opposed to assets, because
well, yes.
what ultimately why you end up with more or a higher incidence of Black people being pushed into 13 is because there was also a corresponding higher incidence of Black people being put into very insecure mortgages during in the lead up to the financial crisis.
Absolutely. I'm given the theory. It's not working like this in practice. In reality, the vast majority of people who file for bankruptcy have low incomes across the board. And African American families are homeowners at a way lower rate than white families in America. Their mortgages are more costly. However, that's not what's driving African Americans into Chapter 13. It's the fact that all those new twists and turns, well, this is one of the factors anyway, all those new twists and turns made lawyers charge even more money to file. Now, I shouldn't make it sound like they're charging a whole lot. They charge for an entire case what some corporate lawyers make in an hour over in corporate bankruptcy. So everything has to be in perspective. But for a family who's already spent their last dollar trying to keep themselves out of bankruptcy, they don't have it. Chapter 13, you can pay your lawyer over time. And in Chapter 7, you're supposed to pay your lawyer up front. That is hitting African American families very hard. But it is more than that, I have to say.
So there's a predatory aspect of this in terms of, or is it the attorneys are approached, they see someone with no assets to pay them up front for a Chapter 7. So they're basically forced, their clients are forced into a Chapter 13 because they don't have the means in which to pay for a Chapter 7 proceeding, essentially.
Well, I'm going to hold back on the word predatory. I think some of these lawyers' offices are very small businesses working on not a lot of resources. So this is where the second part of the disparity comes in on the filing level. There have been studies that show that when families are given two families with the identical financial circumstance, but one has features, their names, what church they go to, that signals that they're Black, and another that signals that they're white, lawyers will make very different recommendations for those two families, that they will recommend the longer, harder approach to bankruptcy, the more expensive approach for African American families more frequently than they do for the white families. And so where I'm going with all of this is that...
Do we know why?
Well, those who are researching this come up with a couple theories. There is some stereotyping going on. There's some understanding of who is more and less responsible. Lawyers, even in another study, when asked to estimate how many white people and Black people are in Chapter 7 and Chapter 13, bankruptcy lawyers overestimated the white people in Chapter 13 and underestimated the Black people in Chapter 13. Again, the law professor and psychologist who worked on this talked about stereotyping, and we often call it implicit bias that's going into this. But I don't know
So it's like almost an analogous dynamic to doctors prescribing less painkillers to African American patients because of some combination of like they don't recognize the legitimacy of the pain that African American patients are in, or that they have some notion of like, I have more exposure here because I have some unconscious or more or explicit belief that they're more likely to be painkiller abusers or something, or drug abusers. I mean, so it's that type of dynamic, whether conscious or unconscious, by these attorneys.
Well, I think you're right to make some broader analogies here, because this is not a phenomenon unique to bankruptcy. I think the message I'm trying to convey in Unjust Debts is the hierarchies and biases that we see in society are reflected in bankruptcy, but then they're really compounded because of the tools and the consequences of the bankruptcy system. But I do think that looking at other circumstances where it might be implicit is important, because we have to solve this problem together. It's not going to be about pointing fingers at people and calling them racist. That's not going to work. On the other hand, we do need something done about this. There has to be structural reform to the personal bankruptcy system, because that is the most important thing that our bankruptcy system does, is provide debt relief. And we have to reduce that racial discrimination. We have to seek to eliminate it, if at all possible.
And frankly, the overall, not just that disparity, but the way that personal bankruptcy operates versus, let's say, Chapter 11, which is corporate bankruptcy, is much more problematic, because if I go into Chapter 11 as a corporation, I get immediate protection, and that is one element that's problematic. The other is this so-called Texas two-step, which, I think our audience is a little bit familiar with in the function of we do a lot of coverage of mass tort cases, whether it's this Johnson & Johnson case over talc, which was found to be cancerous, or DuPont with the PFAS case, or with the Sacklers and Purdue. The bankruptcy is now being used on a corporate level as a way of escaping not just debt from creditors, but almost like a future debt or a hypothetical, because it's a liability because they've harmed people.
Yes. So in talking about the types of concerns I have about corporate bankruptcy, we start with the idea that, again, on a bipartisan basis, Congress decided to do a protective expansion of the ability of a company to reorganize. That's kind of an extraordinary thing. They don't have to be dismantled. They get to continue. And the idea is that it's better for workers, better for suppliers, better for communities, and there has to be a certain amount of buy-in from creditors. It works pretty well when done in a traditional way. And by that, I mean with creditors who have contracts that, whether they're suppliers or whether they've loaned money, and a case that goes all the way through and the creditors vote and it follows the blueprint that Congress chose. There are two ways that cases are going off the blueprint. One is cases moving super fast and selling companies within weeks or months without all the protections for everybody else. But the second that's gotten so much attention right now is that because the bankruptcy law defines debt so much broader than our common conception, people are sweeping everything in. And while I think Congress knew that it could be in sort of an ad hoc, that there might be some tort claimants in a bankruptcy case, when Congress wrote the bankruptcy code in 1978, they did not anticipate it's being used only for tort claimants, and especially, as you've pointed out, Sam, for people who don't even know that they're injured at the time of the case. And that's an issue that is really left open by the Purdue Pharma decision in the Supreme Court, although I can see how some people will argue it's closing the door to that. There's a good argument for that, but it really wasn't centrally presented in the case.
And so, in other words, that a corporation can realize, oh, we've harmed maybe 1,000, maybe 10,000 people, or 100,000. We don't know exactly yet because the case hasn't even gone that further, and use bankruptcy to escape that liability that is just hypothetical.
Well, it is hypothetical, and let me offer what the corporate restructuring lawyers would say in response to what you just said, which is they're not escaping it. They are managing it so that the money is allocated equally to people. Now, that sounds good in theory. I've written about in the book and in a New York Times essay a couple weeks ago that that's not how it works out in reality. What's promised is not always delivered. But there is money set aside to pay people. A lot of it does go to lawyers. Let's just make that clear. But it's not a complete blockage. But these cases are so much more than just about money. They are about control. They're about accountability. They're about people who've been injured telling their stories. And all of that goes by the wayside, at least in modern bankruptcy practice. I think there are things that can be done if these cases stay in bankruptcy. But there was an optimistic story to this. Senator Elizabeth Warren, who's going to be interviewing me later today for the Commonwealth Club at 3 Eastern Time, used to believe strongly that if there was enough information about what the company did wrong and enough lawsuits that have already happened, that it might make sense to try to package everything together, set up a trust that's adequately funded. That's right. The key, adequately funded, and that so people that are hurt 10 years from now aren't out of luck. I'll be curious to see if she asks me questions about this and how it's working now. But there is an optimistic part of the story. I'm just very skeptical that it's working that way, and that it doesn't resolve all of the questions we should have about it.
Is there any movement in Congress to reform the bankruptcy laws, either, to include things like student debt or to decrease the harshness between Chapter 7 and 13, or I should say 13 and 7, and to minimize this opportunity for corporations to escape liability, and also simultaneously deny plaintiffs the opportunity to sort of get compensation in other forms, some accountability. Is there any movement on this in Congress, or are we just in an era of like the law in this area is just sort of fallow for the moment?
There is movement on these issues. Now, getting them over the finish line, of course, is a very different story. There actually are legislation, there are bills on every issue that you've raised, including pushing together Chapter 7 and Chapter 13 so that there's one personal bankruptcy chapter that would do so much to address the racial disparities, especially given some of the technical details of that law. There are bills that try to look at sex abuse bankruptcies and give, by which I mean the Boy Scouts, Catholic dioceses, all of which are filed only to deal with child sex abuse allegations. A bipartisan bill is dedicated to looking at giving more of a voice to the survivors and making sure that these entities are honest about where they've planted their various resources when we're talking about the diocese or anything else. The question is the movement for that. And one reason I wrote Unjust Debts for the public and not to talk about only in the faculty lounge is because, again, these issues relate to corporate power. They relate to everything we've talked about around elections, and it should be part of what people are concerned about, or at least is consistent with what people are concerned about. So that there needs to be more pressure from the public to look at these issues to make the system more fair.
Melissa Jacoby, law professor at University of North Carolina, Chapel Hill. The book is Unjust Debts: How Our Bankruptcy System Makes America More Unequal. We will put a link to that at majority.fm, and really appreciate your coming on today.
Glad to be here. Thank you.
Thank you.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.